that Mr. Cipollone was among those who were in the loop. Yet another reason why we ought to hear from witnesses. Just as we predicted, and it didn't require any great act of clairvoyance, the facts will come out.
So let's ask Ambassador Bolton these questions directly under oath. Why did you use the words drug deal? We should ask him that. Why did you urge your staff to report concerns to lawyers? These are all questions that we can get the answers to.
But if the president did nothing wrong, if he held up the aid because of so-called corruption or burden-sharing reasons, he should want his chief of staff to come testify under oath before this distinguished body and say just that.
It's not just about hearing from witnesses. You need documents. The documents don't lie.
But it's not that simple. And that's really something that is a trope that's being used to disguise the real issues, the real decisions that you'd be making. No witnesses are going to say anything that makes any difference to the second article of impeachment.
Over a 7-day period, you did hear evidence. You heard evidence from 13 different witnesses, 192 video clips, and as my colleague, the Deputy White House Counsel said, over 28,000 pages of documents.
The question is, shall it be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents? If not, the yeas are 49, the nays are 51. The motion is not agreed to.
At the conclusion of the final arguments by the House and the President, the Court of Impeachment shall stand adjourned until 4 p.m. on Wednesday, February 5th, 2020.
Mr. Majority Leader?
I ask unanimous consent that the Democratic leader or his designee be allowed to offer up to 4 amendments to the resolution. Further, that I be recognized to make a motion to table the amendment after it's been reported with no intervening action or debate.
Chief Justice Chase, as presiding officer, cast tie-breaking votes on both March 31st and April 2nd, 1868.
I am, Mr. Leader. The one concerned a motion to adjourn, the other concerned a motion to close deliberations. I do not regard those isolated episodes 150 years ago as sufficient to support a general authority to break ties. If the members of this body, elected by the people and accountable to them, divide equally on a motion, the normal rule is that the motion fails. I think it would be inappropriate for me, an unelected official from a different branch of government, to assert the power to change that result so that the motion would succeed.
I send an amendment to the desk to subpoena Mulvaney, Bolton, Duffy, Blair, and the White House, OMB, DOD, and State Department documents. Mr. Chief Justice, I send an amendment to the desk to subpoena John R. Bolton. I send an amendment to the desk to subpoena John R. Bolton, provided further that there be 1 day for a deposition presided over by the Chief Justice and 1 day for live testimony before the Senate, both of which must occur within 5 days of the adoption of the underlying resolution.
Mr. Chief Justice, I send an amendment to the desk to have the Chief Justice rule on motions to subpoena witnesses and documents and to rule on any assertion of privilege, and I ask that it be read.
The yeas are 53, the nays are 47. The motion is agreed to. The resolution is agreed to. Mr. Majority Leader?
Further, I ask unanimous consent that when the Senate resumes legislative session on Monday, February 3rd, Tuesday, February 4th, and Wednesday, February 5th, the Senate be in a period of morning business with senators permitted to speak for up to 10 minutes each for debate only.
Without objection, so ordered.
And finally, I ask unanimous consent that the trial adjourn until 11 a.m., February 3rd, and that this order also constitute the adjournment of the Senate.
Without objection, so ordered. We are adjourned.